morning, everybody, and welcome to today's SVDX webinar. My name is Nancy Easterbrook. I am Executive Director of Silicon Valley Directors Exchange. We're delighted to have you joining us today for today's session on D&O trends, and a special thank you to Heffernan Insurance Brokers, who is co-sponsoring today's session. We will have a 1-hour webinar, and we encourage you to submit your questions via the Q&A feature on Zoom. We will try our best to fold those questions in throughout today's conversation, so please don't wait until the very end to ask your questions. It's really my pleasure to introduce our wonderful panel of speakers for today. I will do very short introductions before we get started on today's webinar. Richard Blake is a partner at Wilson Sonsini, Goodrich & Rosati, and the leader of the firm's public companies practice. He practices corporate and securities law with a focus on public company representation, corporate governance, and public offerings. Richard has represented public and private clients across a broad range of industries, as well as investment banking and venture capital firms, and has been lead counsel on IPOs listed in PitchBook's top 10 US VC-backed IPOs for many years. Catherine Henderson is a corporate governance and litigation partner at Wilson Sonsini. Catherine specializes in conducting investigations on behalf of management, boards of directors, and special board or management committees, advising companies faced with stockholder litigation demands and representing companies in stockholder actions and busted deal litigation. She also advises with respect to directors and officers' liability insurance coverage and indemnification issues. Ed McGee is a C-suite executive and combat veteran with 17 years of global supply chain management and operations leadership roles. Mr. McGee has extensive experience building and developing global leadership teams that drive organizational and culture change within high-profile brands, including Harley-Davidson Motor Company, ABB, and Fender Musical Instruments Corp. Mr. McGee is an independent director on the board of WD-40 and serves on the audit and finance committees. Our moderator for today, Joe Talmadge, is Executive Vice President and Technology Practice Lead at Heffernan Insurance Brokers. Joe has been a lead broker for high-growth pre-IPO companies since 2001 and specializes in D&O and global risk management strategies. His experience includes working with hundreds of high-profile venture-backed and publicly traded companies across various industries, including technology, biotech, healthcare, food, energy, media entertainment, real estate, and transportation companies. Once again, welcome to today's webinar. Thank you for joining us. Special thanks to Joe, Ed, Richard, and Catherine. Joe, I'll let you take it from here.
Great. Thank you, Nancy. And thank you to the Silicon Valley Directors Exchange for sponsoring these types of panels. I think they're incredibly valuable in promoting awareness of what's happening in the market and just general governance and questions that directors can ask. And thank you to Ed and Catherine and Richard for taking the time to sit on this panel. I think your experiences are incredibly valuable and looking forward to the discussion today. So part of the thinking when we set up these panels with the Silicon Valley Directors Exchange is, what's happening today, what's relevant, what's going on in and around the world of risk, particularly with the lens of a director and an officer for that matter as well. And because there's so much market volatility, we thought it would be interesting to talk a little bit about that. And how does that bleed into the way that we're thinking about insurance, the way that we're thinking about risk management, the way that we're thinking about the interplay of the potential insurance policies or lack of insurance policies that don't address certain risks? What are the things that directors can be asking? What are the things that executives can be asking? There's so much to talk about. I don't know if we will cover it all in this hour today, but we thought that the backdrop of the market volatility and the tariffs and the legal changes in the US and abroad, the geopolitical environment sets the stage for a really interesting discussion to be thinking about these things. So I'm going to cover just a really brief overview of the D&O market before I start inquiring with our panelists just around the underlying factors that can mitigate risk before it even gets to insurance, as well as some of the trends that they're seeing with the lens that they sit in. All of them have tons of experience that I think will shed light and context on these things. So in the past, I would say 5 to 6 years, there's been a pretty dramatic change, and you may have sat on other panels talking about D&O rate trends. There was some in legal environment changes that caused legal costs and settlements to more than double in 2018 to 2020 period. So we saw a huge increase in D&O rates, a very large increase in self-insured retentions on D&O programs, public D&O specifically. Uh, the minimum self-insured retentions that a broker organizing a public D&O program could get in the market was about 15 to 20 million dollars, where historically you could get them as low as $500,000 to $1 million self-insured retention. Um, that changed, the environment changed, and companies started adopting federal forum provisions, and there was a substantial reduction in rates, both in premiums as well as the available limit in the market. So from the period of 2022 to 2023, we were seeing 25 to 30% decreases in premiums. We were seeing more limits being offered from the insurance companies. In the past 2 years, that has stabilized a bit. We're seeing flat to anywhere from 5 to 15% decreases, depending on the risk profile for the companies. We're also seeing a pretty substantial drop in self-insured retentions that D&O underwriters are willing to offer companies. So where they may have been restricted to only offering 5 million or 10 million before, they're now going down as low as 2.5. I've seen as low as $750,000 self-insured retentions. That's going to be different depending on if you're an IPO or a more established public company. But those metrics are pretty dramatic in terms of where we were even just a handful of years ago. An example that I like to use is a $5 billion market cap company that we were working with, who just a couple months ago, we were able to get an additional $10 million of Side A coverage on their tower for less premium than what they had expiring. And we even had offers to drop their self-insured retention from 15 down to 5 for an equivalent premium. So if that gives you just a context of where we're at. And by the way, that was a highly volatile technology company. And so even in that sort of risk profile, we're still seeing some pretty favorable terms being negotiated in the market. Interestingly, what we are also seeing from our boards and our executive teams is that while the majority of the risk for these policies is in the first $15 million of the tower, we're not necessarily seeing companies drop their self-insured retentions down to those lower levels. What we are seeing is that they may drop it a smaller amount, but they're actually much more interested in the catastrophic risks in the Side A towers. So we're seeing increases in towers of coverage for D&O now that the availability of the coverage is more affordable, and they're able to make those decisions to protect their boards and to protect their executives for the more catastrophic events. And I think some of that is coming from the derivative trends that we're seeing. That's been another change that has been pretty watched by D&O underwriters. There's been some pretty substantial derivative litigation. 2023, we had a $735 million filing against Tesla for unfair and excessive compensation to the board. In 2021, we had Boeing breach of oversight obligations. That was a $237 million derivative litigation. The list goes on: Wells Fargo, American Realty Capital Partner, Google, all of these exceeding $200 million in derivative litigation. There's also a case that I'm sure Catherine and Richard can speak to if they want, the Ren case, which was a $300 million derivative case that kind of shed light on foreign-owned companies and the way that those suits can be brought in the US. So that trend is leading our directors and our executives to think about the Side A layer a little bit differently, bolster it up a little bit differently, but in a different way than they were bolstering it up in 2018, which was more to save premium, whereas today it's more to protect the board. Um, so those are some of the general trends as it relates to rates, self-insured retentions, the tower structures, buying behavior that we're seeing with our boards. Some other very interesting trends are insurance companies offering things that they haven't offered in over a decade. Full investigative coverage, where usually it's been pretty restrictive in terms of how much investigative coverages you can get. They're offering higher limits on books and records coverage. And there's also really interesting parametric D&O products that are coming into the market that are event driven. So you're a company, you have a stock drop over 20%, and you have a securities class action filing within a year of that event, the policy automatically triggers because those two things happened. It's a totally unique way of looking at risk, and it's the first time that we've seen the idea of parametric insurance, which is typically used in natural perils for flood, fire, wildfire, and other natural peril events, come into a casualty market where you have these financial risks that are associated with events. And so it's the first time that we've seen that in the D&O market. And the way that we're looking at boards and executives evaluate these products is let's learn about them first. Can we use them to address risk that is uninsurable? Uh, and is it needed depending on our perspective on what those uninsurable risks are? Because they aren't insurable and because this is a parametric product, they're event driven. They're really interesting topics to talk about and get the conversation going at the board level. So those are some of the things that we're seeing on the insurance side. Um, I'm going to switch gears a little bit and turn the tables over to our panelists. And I'd like to kind of get an understanding of, now that we've talked about available insurance, available trends in insurance, I'd like to get some perspective from each of you on just setting the stage for our audience on the environment that a director is navigating today. Um, we'll start with Richard and then maybe Catherine and Ed, if you guys want to maybe share your perspective on how you see the environment today and what you think the stage that we should be, or what lens we should be asking questions about risk at the board level.
Yeah, thanks, Joe. And I always love having someone like Joe sort of give me an update as to what's going on in the D&O market, because the last few years it's sort of whipsawed around a little bit, and it's super helpful to get that sort of insight from a legal perspective. And as Nancy said, I'm a corporate lawyer, and Catherine and I work together sort of as a corporate and a litigation team, sort of two by two. I sort of give the perspective of how a corporate lawyer thinks about these issues, and Catherine gives the same perspective from a litigator's perspective. So I think in it, as the insurance market is becoming more favorable, I think, for companies and for boards, I think from a legal perspective, there's also some trends that have been helpful. Some of them a little bit countervailing, but at the most part, I think there are things happening to sort of help officers and directors a little bit more. So, for instance, in the last couple of years, there's been on the one hand that's sort of maybe anti-director or more challenging for directors. There have been a number of suits talking about the duty of oversight, where boards have an obligation to oversee particularly the mission critical risks that companies face. So think like for food safety for a company that's manufacturing food. There was a case about Bluebell ice cream where a listeria outbreak occurred, and a number of people died from eating Bluebell ice cream. And at early stages of litigation against the company, they had found that there was very little record in the board minutes of directors talking about food safety, which you sort of sit back and think, how is that absolutely possible that the most mission critical risk that a company faced, like the board didn't even talk about it, or at least they couldn't find evidence in the board minutes. Boeing, air safety. Obviously, the most important thing for an aircraft manufacturer is the safety of the product that they make. Also in early stages of litigation. So there's on one aspect, and the law in this area hasn't changed. It's just there was a bunch of lawsuits with bad facts, which has caused us to remind boards, hey, look, in your oversight of risks, make sure that you're looking at things, but also that you're documenting that you are looking at things, that the minutes reflect that you had oversight over these mission critical risks. As we see another development that's actually more positive for executive officers of companies is as we see not just directors being sued for breaches of fiduciary duty, but also officers in their capacity as officers being sued. Those suits have increased, and as they have, the Delaware law has expanded and provided additional protection for officers. So in the last couple of years, I think it was 2022, if I'm not mistaken, or 23, Delaware amended its laws to allow companies to put in their certificates of incorporation additional protections exculpating officers, allowing them to get out of lawsuits earlier at the same time as board members who also have full exculpation. And so we've seen a lot of companies add exculpation provisions in their certificate of incorporation, which does actually require an amendment to the certificate of incorporation, a stockholder approval for it. But that gives added protection to officers of companies to help them get out of lawsuits at an earlier stage, the same way that directors can. Delaware is constantly sort of tweaking its laws to help respond to the market. And as plaintiffs' lawyers get more creative and bring more different sorts of lawsuits, the Delaware law responds. Another area that the Delaware law has recently responded to, Joe, you were talking about 220 demands. These are demands that stockholders who own a minimal amount of stock can ask for corporate records to try to find if there's misconduct or things like that going on so that they can then bring suits on it. Delaware recently adopted some amendments that will rein that in slightly. So as plaintiffs' lawyers get more creative, Delaware law responds, which is one of the reasons why Delaware law can be super helpful, because they are quick to respond to improve. I think from a corporate perspective, one of the best ways that directors and officers can help protect Joe sells life insurance or D&O insurance. I sell another type of insurance, which is risk factors. Well-drafted risk factors can help get you out of lawsuits sooner rather than later. It's easy insurance, much cheaper than the kind that Joe sells at some level. So that's one of the reasons why we, as corporate lawyers, when we review public company filings, we're digging in, we're trying to make sure, talk to the company and understand the risk environment so that we can make sure that that's adequately described. But Catherine, you have perspectives on all these and other issues too. Maybe I'll let you sort of respond to what I've said and add on to it.
Yeah, no, I mean, I think all of that is very critical when I am then litigating the lawsuit that's brought, a couple of years down the line after Richard's making sure your risk disclosures look great. Richard and I have been talking a lot about risk disclosures in recent years because they are becoming increasingly important in litigation. So stock drop cases, and this is a big topic right now because with all the market uncertainty, you're likely to get a stock drop case, right? If the market goes down, your stock goes down, the plaintiff's bar is going to start buzzing around and see if they can come up with a basis for a case. So it's just the reality of where we are right now. And I think risk disclosures and making sure those risk disclosures are really well crafted and very thoughtful is the most important piece. Because a increasing trend, particularly here on the West Coast, is that the plaintiffs themselves are scrutinizing those risk disclosures and actually pointing to them and saying, these are the things that are actually misleading. These are the things that are false. And so they'll point to, and there's been some really, very key cases in the Ninth Circuit on these issues with some of our big tech companies, where the plaintiff said, you expressed that these risks were hypothetical. And you knew at the time they weren't hypothetical, they had actually already arisen. So your risk disclosure itself was actually false and misleading. So that's really where we're seeing a lot. And I've been litigating one of those cases myself over the past few years. And the plaintiffs are really trying to stretch that case law. So making sure you're thoughtful. And I think what sometimes happened in the past, and Richard and I have talked about this, right, is you have the same risk disclosures every quarter, every year, and you're kind of tweaking them a little bit. but oftentimes they stay the same and they're not necessarily being adapted to current circumstances. And the big area where we're seeing this be an increasingly important issue is cybersecurity, right? So everyone's got a cyber risk disclosure talking about hypothetical breaches, right? Well, what if you had an actual breach? So that's where we've seen some of the case law where the courts say, look, if the plaintiffs can show that you had an actual breach at the time that you put this risk disclosure out, saying it was hypothetical, well, then that risk disclosure is all of a sudden now false and misleading. And you're going to be stuck in a lawsuit for years, right? You may have to settle it, whatnot. And that's where we've seen this case law get expanded. So really the importance of sitting down each time you're putting disclosures out and not reflexively just putting the same things in. And if you've got an incident or you've got a cyber incident or something else, I think the tariffs are going to be another issue, right? Where you have to look at what is in your filings as hypothetical and say, is it really still hypothetical? Or do I have information showing that that risk has now moved into the reality? And is what I'm saying in here true? And I think that's important for directors because sometimes the legal department is looking at these. They may not have the same information as the directors, or people are not thinking about it critically. So I think you need a lot of brains on that. Your counsel obviously will be doing it, but as a director, take a look at what you're putting into your company's filings and say, should we tweak this a little bit? And I think Richard has a lot of discussions about that. And I've gotten involved in some of those because you've got to look forward to the litigation that's filed 2 years from now. And this is what I'm going to be litigating is whether your risk disclosures are accurate or whether they are misleading in light of these facts that have now come up. So I think that's one of the most important things folks can do right now. The other thing is, of course, board materials. Richard referenced these new cases where and this is why Joe was saying the cost of insurance has gone up because there's a lot more derivative cases going past the motion to dismiss stage. And this is all the name of the game and what I do is, right, can the plaintiffs get past a motion to dismiss? Because there's no discovery while I'm briefing a motion to dismiss. Cases get expensive when they get past a motion to dismiss. So on stock drop cases, your risk disclosures are super helpful in letting us stop those cases at that point. Derivative cases are the same thing, but they're more focused on board materials because we had all these 220 productions and stockholders would be getting this slew of material, board minutes, board presentations, whatnot. And they make assertions about not only what's in there, but what's not in there. And they can make all sorts of inferences based on that. So you've got to be thoughtful about the record that you're creating. And sometimes we all do short form minutes, right? Traditionally, a lot of times we're not talking about details. You got to be thoughtful about that these days. If you've got a sensitive issue, do I need to put a little more detail in my minutes to show that I did think about this as a director, that we did talk about it, so that the court can now see that as part of the board record? And I get involved in drafting board minutes these days, right? Which is not typically the litigator role, but that is where it helps me 2 years down the road say, what are you talking about, Your Honor? Look at this lovely board discussion where they talked about food safety or whatever the issue is. Again, cyber, I think, is a big issue on this. And this is where you want to be engaging, I think, with your counsel to make sure you're creating a record that'll help you in litigation down the road. Well, I'll turn it over to Ed now. Like, we've given you the lawyer spiel here. Now, how's it all working in practice?
All right. So in contemplating how to synthesize all of this, I came up with a little tagline. I was at a recent event with Roy Spence, who did the "Don't Mess with Texas" campaign. Amazing communicator. And here's my synopsis: RAD governance for a VUCA world. And what is RAD? Resilient, agile, durable governance. Think Warren Buffett. For a volatile, uncertain, complex, and ambiguous world. And as a veteran and also the chair of NACD Nashville, my big observation is the risk environment is accelerating. Speed, scrutiny from stakeholders, expectations are accelerating, and you've got to think ahead of the environment. So what do I mean by that? The risk environment is definitely outpacing the board's cadence. So you can't just be a great board member in the board meeting. You got to think about your prep work before the meeting. You got to think about how you engage in the meeting, and then you've got to think about how you continually engage with the risk environment outside of the board meeting. I mean, with things like AI, ESG backlash, DE&I, tariffs, all of these things are happening outside the normal boardroom cadence. So the mindset of the director has to change, and that cadence mismatch has to be met with what I call an always be learning mindset. We've got to constantly think about what is going on within the context of risk, the business, stakeholders, and really just be open to continual learning. Second big piece is what you heard from our amazing lawyers. Both the market and legal shifts require proactive governance. We can't be that board member that just reads the board deck and walks in and asks a question. That's not our job anymore. As you heard earlier, the consequence for operating under that old construct is, claims and frequency severity, or litigation severity, especially with derivative lawsuits, are up. So we've got to really think about our role as a board member, and the level of learning and the synthesizing. One of my mentors said, board members are masters of pattern recognition. So the patterns are changing more quickly these days, and we've got to adjust the way that we learn, the way that we engage. I think our amazing legal team has articulated the fact that Caremark oversight has teeth. We can't do check the box governance anymore. So we've got to triple click on disclosure accuracy. We've got to think about the context for the disclosures, and especially around topics like ESG, cyber, M&A. All of those elements really, don't ask the first question. Think about the quality of the answer to that question, and then what are those second and third order questions that you need to contemplate. And for great board members, you may not want to do that in the board meeting. You may want to make sure that there's follow-up. You talk to general counsel, you talk to board leadership, and the element of follow-up is critical. And my big takeaway from studying and being around these great minds is your D&O insurance does not mask weak governance habits. If you've got terrible governance habits, you can't have enough D&O insurance. So directors have to do their job. They've got to do their role. And, there's context for all of this. And, the director's role representing the shareholders is of incredible import. So develop better pattern recognition, ask better questions, do your studying before the meeting, know what a good answer is, and ask questions like, how do these different types of insurance actually interact? How does my cyber insurance interact with my D&O insurance, interact with business continuity insurance? All of those things are going to come together when you have an event, and the time to learn about that is not when the event happens. You've got to ask those questions before. Last thing I'll say is, just the idea of a culture of active learning. You got to attend these types of events. You really got to, I'm chair of NACD Nashville. I'll put in a plug for NACD Nashville, and certainly the Northern California chapter is exceptional. But you've got to be engaged in learning, active learning, to be an effective board member these days.
Wow, that was a lot. Thank you, Ed. There was something that Catherine mentioned about the market volatility and stock drops and the probability of a lawsuit. And if the audience wants, we can follow up with the material afterwards. But there was a really good analysis that was done out of the Stanford Securities Litigation Analytics Group. Professor Michael Klausner, Sam Blake Curry, and Jason Haglin did it. And they did it in conjunction with a close colleague of mine and good friend that I do quite a bit of business with, Kevin LaCroix, who writes the D&O Diary. But it was really insightful because we have this assumption that, stock drop, automatic lawsuit, and there's a lot of contextualization that goes behind it when you look at the numbers, because it doesn't quite happen like that all the time. So I think understanding what size of company you're on, what industry that you're in, and knowing what these metrics are, it might influence how you're thinking about what might happen in the event of a stock drop. And one of the things that came out of that is that, surprisingly, you could have a relatively large company, $2.5 billion market cap company, and experience, 15 to 20% stock drop. And the percentage of those companies that were sued was only 6%, a little over 6%. I mean, that's a pretty large risk to have with that number. Now, you bring the stock drop to over 20%, that number goes up closer to 20%. And then you change the quartile of the company, you get into the larger mid cap and large cap companies. Those same thresholds, you're not at 6% anymore, you're at almost 30% because there's a lot more economic interest in the plaintiff's attorneys. So, and it goes up even higher for the larger companies with larger drops. So, I think not all directorships are the same. Really understanding the context of the company that you're sitting on, the financial risk of the company that you're sitting on, and what that means to you in terms of a probability of a claim is helpful for understanding how you're thinking about your D&O limit selection and the way that you want to approach that. The other thing that came out of some of the discussions that you had went through was this idea of the interplay of different insurance programs. And the reason why it's interesting is when you look at these large derivative litigation cases, most of them are tied to, board conflicts of interest, M&A diligence, some kind of egregious behavior towards, your employees or your customers, consumers, bodily injury to the public, fraud. So all of these things, when I put these out there, and I think as a sort of enterprise risk person and looking across the organization globally, there is a probability that there may be another insurance policy involved in that matter. Catherine mentioned cybersecurity. Yes, it is a very big deal. Well, guess what? Most of these cybersecurity underwriters know that there are requirements with the SEC, and they're adding different coverage provisions on the cyber insurance policy to, in good faith, help you out if there's a cyber claim. The challenge with that is that all of a sudden you're now triggering other insurance provisions, which basically say if there is other insurance involved, our policy is secondary. So that can complicate matters in an event like that, where you have multiple adjusters, multiple attorneys involved, trying to figure out what the strategy of a claim is, as well as the requirement to get consent from these insurance carriers who may be participating on a shared allocation in a particular claim. So have you as a director asked your GC to sort of map those potential overlaps on contributions to these risks that really matter to the company? You brought up food contamination and recall as a potential risk. Same thing there. Has that silo of risk, bled into the GC's awareness of how those two policies are going to interact with each other and respond with each other? Bodily injury, you have general liability insurance. A lot of times companies are looking at these things in silos of risk, but at the board level, it's affecting everything. And so I think you brought up a really important point, Ed, is the interplay between these coverages, and are there questions being asked that really give you guidance on how these policies are going to respond or not respond when this event happens?
And typically you hit, D&O as we're going to look at D&O insurance. Great. You've got to have your GC. And this is something that I took out of our prep session, just reaching out to the GC and say, look, when we review this, you've got to map it out before the meeting so that we can actually start taking a look at that interaction. But yeah, that was one of the best parts of our prep, actually making its way into the boardroom.
And I've seen that actually play out in real time where every policy has the provision Joe talks about, right? Where it says there's other coverage on secondary. Well, if you have two policies that both say that, and it's like a game of hot potato, right? Where they want to pass to each other. And that can be really complicated after a claim comes in. Before a claim comes in, you've got a lot more, that you can work with if you can scout it ahead of time. It's really helpful to have, the same broker, right? Like looking at all of these things so that they're not siloed into different positions. Because people don't actually know there are exclusions, right? A lot of D&O policies will have an exclusion for bodily harm. That's pretty typical, but now we're getting carved backs to it. So if there's a carved back, then how does it relate to your, general liability policy? There's a lot of complications there, and particularly as we're like kind of tweaking them every year, right, to get more coverage into D&O. On these different areas when you have a separate cybersecurity policy, I think it's really important to think about that holistically.
And quite honestly, we do tabletop exercises for cybersecurity. Take one of those examples and just walk that example through all of those types of insurance. And I think it's a way that you can get your board up to speed quickly and in real time really understand that interaction is absolutely critical. So
I'd like to go back to the legal environment changes. You scratched on a couple of topics. Are there any other major legal environment changes that our audience should be aware of? This question is more for you, Catherine, Richard, and then maybe a follow-up question to that is, you mentioned briefly, Ed, the cadence of review of these changes. Like, how should directors be thinking about how frequently they're reviewing these things? And then I have a follow-up question to that as well, around tariffs.
Well, I mean, I'll let Richard weigh in on the cadence because I know you're more involved in that on an everyday basis. When I'm getting involved, there's usually something catastrophic that has happened or you've already been sued. Ideally, I get involved before you get sued so I can be more helpful then. But certainly if you've had a cyber event, you need to look at everything. If you've had some sort of big ticket, like an M&A transaction, you need to be looking at everything. What we're talking about is all these cases on the governance front really talk about Delaware law and the entire fairness standard. And that's probably something you've heard kind of pop up. But what it really means is if you're under entire fairness, I am very unlikely to get that case dismissed. It's probably going all the way. And the big ticket cases that Joe talked about are all entire fairness cases. If you've got a controlling stockholder, if you've got a large shareholder that's not necessarily a controlling from a stock percentage, you need to be thinking about this. If you have a case where you've got a CEO who's more, an outsized personality or has a lot of control or friends on the board, you've got to be thinking about how a court's going to look at this. And then what's your risk profile if you engage in a transaction where they get a special benefit or whatnot. So, you mentioned the Tesla litigation that was about Elon's pay package. And even though he's not a majority shareholder, you're still seeing the court engage on this entire fairness. M&A transactions where you've got to control, you're seeing the same thing. Now, Delaware's been doing work to actually try to help bring down the prevalence of those cases and the ease at which plaintiffs have in bringing them. And there were some recent amendments that happened earlier this year that I think will be helpful in that. It's always hard to see how things will play out because I think someone said earlier the plaintiff's bar is quite creative. And that's really the give and take of Delaware entirely. So you don't get too burdensome with litigation, but you try to make it so that it's hard to bring these cases, but you want them brought when there's a real reason. And I think that's what we're seeing, the give and take. So when you've got those sort of special circumstances, the board needs to be way more involved. You really need to be looking at things earlier because you're more likely to see litigation down the road. But Richard, I mean, you do this stuff every day. What do you think in terms of cadence?
Yeah, so you hit on a couple things there that I'll just follow up on. So one is, if there's a transaction going on where somebody in the board has some sort of interest, right? And a lot of that, it could be a commercial transaction where you've got a director who's maybe an officer of the company that you're doing business with on the other side. Like, just raise those sort of conflicts up early. I have a client who is considering, all of its current strategic alternatives and maybe starting a process for looking out whether someone could buy them, right? Either a strategic company or a private equity company. And because I think they have some directors who have been involved with M&A events where there has been conflicts of interest and they're hyper focused on it. And they've made sure that every potential contact that the company may be reaching out to confidentially through its bankers, like the board knows about it and they have an opportunity to raise up whether there is an issue. Like, do you have any interactions with any of these companies? Friends or relatives or anything, be it the strategics or the private equity. So they're doing a very careful job of thinking at a very, minute level about the potential for conflicts of interest there. So that, and again, it's not that is damning of the process or would disqualify a particular buyer from being involved in the process. It's just that the board wants to know about it so that it can navigate with counsel and with advisors and everything else around those conflicts so that we keep it in a business judgment as opposed to entire fairness sort of standard, so that Catherine, doesn't have to drag the motion to dismiss on for even longer and maybe get to, discovery. We want to get rid of that case as early as possible. I think on an annual basis, making sure that the company's done a good job with its enterprise risk management process and that those results are brought to the board, documented at the board level, and that we see not just what the risks are of the company, but also the mitigation strategy that the company has around those risks and that the board is aware of that. I think on an annual basis, as we've talked about, digging into risk factors and making sure that the risk factors reflect what that enterprise risk management process suggested. I think because of changes in Delaware law that sometimes affect bylaws and certificates of incorporation, we talked about this exculpation of officers situation. I think, having a routine, I'm not saying every year, but at least every other year, have counsel go through your governance documents and make sure that it's up to date and taking advantage of the full benefits that Delaware law have for you and your company. I think those are some of the cadence things that boards can do. And again, it's not that the directors are doing this. Ed's not doing this. Ed's, I hope Ed looks over the risk factors, but I hope he's not necessarily marking him up the way that we are, but he's making sure. He's like, Richard, are you looking at those risk factors? Are you,
We're paying you a lot of money to do
exactly.
that.
He's overseeing. The board oversees. He's overseeing. Have you looked at our governance documents? Have you done this? And making sure that those things are happening. So,
well, that's a great point. I think this just interaction with the schedule and cadence is the thing that I'm seeing the most impact on. And for example, on some of the boards that I'm on, audit is off cycle from the regular board meeting. And what that does is it gives us a chance to dig into some of those risk factors with enough time to kind of, just discern and let some of those risks cook a bit in the minds of the directors so that when we do go to the board meeting, we can have much richer discussion around some of the risks. I love Catherine's point about risk factors. And again, just the idea that if we looked at all the risk factors every board meeting, our board meetings would be 2 days long. They'd be 5 days long. So what we're trying to contemplate is how do you do the annual review of risk factors? You do your due diligence, but maybe, we take a look at each of the board meeting. What are the top 3? What are the 3 critical ones, especially new and emerging ones like AI or cyber or, diversity and inclusion? What's a hot ticket item that we can contemplate through the lens of, how we talk about risk and also how the management team is actually responding to risk. So, the oversight, it doesn't stop because of the cadence of the board meeting. And I think, your ERM system, the big reviews happen on a more annual basis, and they've got to be done. You've got to do the diligence in that space. But I think with the world changing so quickly, especially for some of these topics, the speed of the threat is just requiring a different lens to take a look at, what we're reviewing, how we're reviewing it, and then also what are the filters that we're looking at to really make sure that an event doesn't become the practice.
We got a question on committee versus board. That actually is a really important question. It came up a lot after these initial Caremark cases came out, like the Bluebell ice cream one. And I started getting a lot of questions of, do you need to have a cybersecurity committee, right? That's totally dedicated to that idea. And that was a big topic in a lot of these panel discussions, and the judges would weigh in, and there's no one size fits all, right? I think the concern I have is if everything gets thrown into audit, there's only so much that audit can do, right? Audit meets a lot more than everyone else, but they've got the financials already. They've got the ERM already. So if you add to their plate, how much capacity is there to really weigh in on these issues? And so to your point, Ed, if you've got your top 3 risks, are you really throwing those all into audit? Or does it make sense to have another committee delving into those? Or does it make sense to do it at the board level? If you've got a big incident, it's probably being done at the board level, right? But leading up to that point, should you think about where is the best allocation of resources? Do we have another committee? You know, I've heard all sorts of ideas, products committees being formed, you know, cyber committees.
AI committees.
AI committees, right? I mean, maybe we'll be hearing about tariff committees soon, but
Yeah.
I think that's the key, right? Is what are our risks, and do we have the resources being attributed to them? And can we show the world that we do? So when I'm dealing with it later on, I have a record.
Can I talk about that? Oh, sorry.
I love just the framing of that is critical, because if you think about like an additional committee as something that is temporary and it's in response to, versus it's a permanent structure on the board. I think that was the delineation that we kind of teased out and said, all right, we just need a couple of board members to look at this particular risk. In one company board that I'm on, we created a separate cybersecurity committee within audit, but it was just the head of audit and me. And you don't need a giant committee looking at everything. So I think, how do you respond to these risks? And they're changing. And then what structure do I have? Is it permanent? Is it just temporary? You know, do I need to get the board up to speed and then make sure that that information makes its way into the actual board meeting? It's just, how do we respond, and how do we use all the tools and not overburden the agenda or all of the board on each of these topics every time they pop up?
You know, Ed makes such a good point here about that it's so dependent on the company and on its governance structures and the time that different people have. And it's not a one size fits all. And everybody asks us, what is everybody doing about the, you know, because, okay, well, I can tell you what everybody's doing. We actually do a governance survey, and we've done it, you know, we're in our 6th year of doing it, where we look at a whole bunch of governance and disclosure topics for the Silicon Valley 150, the 150 largest revenue companies with headquarters in Silicon Valley. It's a great sort of proxy for technology and life sciences companies, public technology and life sciences companies all around the United States. But one of the things we found over the last 5 years that we've been doing this is that the one committee that has been added to boards more than any other is a cyber or privacy committee. Those, as those incidents have become more prevalent, and as governance and disclosure around those topics have become bigger issues, some companies have decided to actually have a separate committee. And Ed, I like what, you know, it's not saying that your subcommittee of the audit committee to deal with cyber is the wrong approach. It probably is, because that's probably the question is what is right for your company. And other companies have done this. We are getting this question all the time now with AI. What should we do about AI? And I'm sort of like, well, is AI taking up so much time in your board meetings that you're not having the ability to talk about other important stuff? If it is, then maybe a committee ought to look at it. But we have a number of companies that already have technology committees. And so that's sort of the right place for that to take, you know, for that discussion to happen. Otherwise, I think it is something that the full board could discuss if it's not taking up so much time that the board is burdened from talking about other issues. Joe, you were mentioning tariffs. This sort of issue of tariffs is a live issue that we're dealing with right now as it relates to risk factors and board oversight and other things like that, right? And we're in an interesting situation, right, where way back during the election, Trump was clear, like, I'm coming for tariffs. And so everybody knew. And then he's elected, and it's like, okay, well, we all think that this is going to happen, but nothing official has been said. And so then something official was said, and finally, recently after the 10K, even most 10K deadlines is like, it was still sort of like, oh, we hear these rumblings, the saber rattling, but nothing official. And then after the 10K, like the official statement came out, and within a week, it was as well, we're going to postpone it all. So as we literally sit here today, there we are in a situation of uncertainty. We don't know, as we're filing 10Qs for the first quarter, exactly what's going to happen with tariffs. And so we're in a situation where we have to say, we don't know exactly what's going to happen. But we do know that and we don't know what's going to, we're going to do something, and then other countries are going to do stuff, and there may be counter. We just don't know. And so in our risk factors, we have to give as much information as we can, but some of it is still uncertain. And we have to say, look, if this happens, then our prices could increase or whatever. If it doesn't happen, then we're still in the state of uncertainty. And even companies that aren't directly impacted by tariffs, meaning that they don't sell products, they don't import or export products that are directly related to tariffs. The whole concept of tariffs is wildly affecting all stock prices and the macroeconomic environment generally. So every company at some level is affected by it and affected by the uncertainty. And we've just got to do our best, and we're trying to do our best with our clients right now of expressing, like, there's uncertainty here. We dealt with this in COVID. If everything blows up, then we may not hit our numbers. It could go a different way, and we could be doing very well. And companies got very good. And I'm not suggesting that we're in that sort of the same phase right now, but I had companies that said, hey, look, we actually don't know. We actually have a high case and a low case. And if, our guidance is in a range, and if these things happen well, then we're going to hit the top of the range. And if these things go badly, then we're going to hit the bottom of the range. And they tried to give as much information as they could in a very uncertain environment so that investors could know. And I think to a lesser extent, maybe that's where we are with tariffs. And we just got to put in the best language we can in our risk factors to help people understand the uncertainty of the situation we're facing.
And companies are pulling guidance.
They're suspending
guidance. Yeah, some of them are suspending guidance. So, not everybody can hide under the tariff umbrella, though. So I think from a governance standpoint, I put on my OPSO hat for a second here, is as a board, you've got to contemplate how risk actually gets digested through your supply chain. It's not enough to just look at, tariffs from the standpoint of financial impact. You've got to contemplate, all right, when the tariff happens, what's happening in the ports? What's happening in the railroads? How am I moving through the entire supply chain? Because that's where I got, quite a bit of leadership scar tissue around finding out, when you finally decide to do something, it's too late because now there's no more room at warehouses to put all of your inventory that piled up because of whatever it is. So board members have to start thinking ahead of the supply chain and the risk, because the company's going to, they're dealing with the problem up close and personal, but really those second and third order impacts is where I think good board members can really, really, really help the companies and the management teams navigate some of these incredibly complex risks.
I think that's a really important point you're bringing up, the second and third level impacts of the tariffs, Ed. And we've got 8 minutes or 7 minutes left now, and I want to get to your final question, and we've got a couple questions coming in on the Q&A. But still on the topic of tariffs, we just published a white paper on insurance and tariffs. Here's everything you need to know about the potential impacts of tariffs and insurance. And I read it, and I'm looking at it going, wow, that's a lot of things impacted in the insurance world. And so if you are a company that has a pretty large line item for insurance, construction, transportation, pharmaceuticals, all of those costs are going up. And guess what? Insurance companies aren't waiting for that to happen. They're pricing accordingly based on the future risk that they are anticipating so that they don't take a hit on their balance sheet. So, you just go through it. Workers' comp is affected with medical costs. Group medical plans are affected with pharmaceutical costs. Rebuilding costs for construction companies there's just endless amount of things that impact the insurance industry. And so if you're a company that has a large item for that, have you asked those questions to understand what's the impact of tariffs for this particular line item or whatever? You can apply that same thought process to whatever line item is impactful for you. So really, really good point, Ed. There's two other questions, and then I'm going to turn it back to the panelists. One was the state of the market loosening it for D&O, terms improving for companies. What do I attribute that to? Very basically, supply and demand. 2018 to 2020, huge rate increases from the D&O insurance market. There was a lot of SPAC activity at that time. Nobody really understood how to price those transactions. It turns out the insurance companies that price them were very profitable. And so there was a lot of interest from a lot of other people that wanted to also get into the market. And so you had a huge influx of additional capital into the D&O market that sort of depressed some of the more established players that were already in the market. And so I would say very basically supply and demand and the profitability of the insurance company's balance sheet for that particular line. Another question came in, Jack, thank you for asking it. Does a multi-year D&O program exist, and what are the benefits and risks of doing so? Yes, they do exist. I would say one of the considerations to considering that is that your limits for that policy period are what they are. So, if you have a 3-year policy period for $100 million limit, you now have $100 million available for all of your management activity over that 3 years. If that was 3 different policies, you would have $100 million limit each year that program was in place. And so the availability of that coverage is very different. We also have clients that, have a program that renews for a year, but for various reasons, usually litigation driven, they may want to extend the policy and approach it that way. So there's a lot of different ways to approach that, but I think just having a healthy discussion with what you believe the risk of the company is can maybe get you to a place where you might feel comfortable doing a multi-year program, because it is administratively easier and you can kind of budget on a more predictable basis what that D&O cost is, because nobody liked getting a 200% D&O increase in 2019. So not a fun discussion to have.
So if companies are going with a multi-year, what's the most frequently chosen number? Is it 2? Is it 3? Just sort of curious.
Yeah, lately I used to see 3 a long time ago, but I haven't seen that in a while. I have seen 2, and I'm talking about U.S. coverage. If you go abroad to foreign D&O placements, it's a much more different environment, and you can get 3 abroad. So we've got 3 minutes left before this panel wraps up. I'm going to give you each a chance to share with our panelists, if they are a new director walking into a publicly traded company, what is the one thing you would want them to walk away from this panel with? We'll start with you, Richard, then Catherine, and then Ed.
I was really excited to hear what Ed said. That we're going to make it Ed. That's going to be like
Ed's going to be the closer.
What Ed said.
Well, I hope I don't steal his thunder. I think, asking questions, right? And asking good questions and following up. If there's something that you don't understand, if there's something that just doesn't seem right or that you're concerned about, go ahead and ask the question. You can ask it respectfully, right? You can ask it, you don't have to be a pain in people's sides about it. But I think just asking the question, making sure you understand either in a meeting or outside of a meeting, and just trying to ask the questions and the secondary questions and the third level questions, just to make sure that you understand what's being explained and why things are happening at the company the way that they are. So.
Yeah, I would just add on to that. The question I would probably focus on is process and governance process and what the company's already doing, and then whether there could be improvements made on that to help, mitigate your risk down the line.
I'd say the impact of a question should not be limited to the board meeting that you're in. You've got to think, about doing your homework beforehand to understand what questions you want to ask. Most importantly, you've got to do your homework such that you know what a good answer is. And good board members also know that you can't chew up the whole meeting getting all your questions answered. So are you doing the follow-up afterwards? Are you meeting with the GC afterwards? Are you meeting with the nom-gov chair or whoever the expert is on the board so that you understand? Because again, the lawsuit cannot be your training grounds for getting this stuff figured out. Yeah.